Yes, Lord. So in this case, the rules didn't provide for cut-off for the interview. It left the discretion to the High Court, so to speak. But in the advertisement, they had given a cut-off. Despite that, it was cut off, it was struck down, saying that this could not have been contemplated under the rules itself. Para 18, Your Lordships, last 3 lines of Para 18. Therefore, in the instant case, in the absence of any statutory requirement of securing minimum marks in interview, the High Court ought to have followed the same principle. In fact, such a fact situation, the question of acquiescence would arise. The reason I pointed this out, Your Lordship, there are different types of change in rules. If rules permit, advertisement does not say so. Rules are silent, advertisement provides for it. Rule specifically excludes advertisement. So there are 3-4 different permutations.
So rules also don't specify, advertisement also don't specify.
That's a clear cut.
Even after the written examination,
yes, Your Lordship.
Before going for Viva OC also, they don't inform the candidate. That's again the fourth
Yes.
category.
Fourth category. So there are multiple ways in which these rules can be changed. So our submission is rules should permit and advertisement should also specify. In that, Your Lordship, there's just this one case. There's another case where again the zone of consideration was reduced. I will not read it, but just point it out, where the number of vacancies were notified and candidates had to be called for interview. The rule was 2 or 3 times the number of vacancies will be called. So the advertisement said 750 vacancies are there approximately, but it can be changed. So 1,500 candidates had to be called for interview, double the zone of consideration. After a point of time, after applications were received, they changed it to 470 vacancies. It was drastically reduced by 300 and only 940 candidates were called for the interview. The court upheld it. This honorable court upheld it, saying that, you know, the notification says that the number of vacancies can change. But the question arises, it says 750 approximately gives you the feeling and the belief that it will be in and around 750. But to reduce it drastically to 470, this would be a clear case where if the authorities had been told you had to give it in writing, the reasons why you drastically reduced it, it may have helped for the purpose of judicial review to see whether it was arbitrary or not. One, and then there's judgments, Your Lordships, I won't read it, but Suresh Kumar, Lalit Kumar Patil versus State of Gujarat, 2023. The last one. Yeah, the last one. Maybe just one last judgment and I'm done, Your Lordship.
Yes.
It's at page 253 of this compilation Your Lordship has. Suresh Kumar, Lalit Kumar Patel versus State of Gujarat.
Page 253.
Yes, Your Lordships. Lordship, the neutral citation is 2023 INSC 145.
Very good. Thank you so much for the neutral citation.
Chair for it. He's the one who pointed
Yes,
it out.
very
He
good.
told me I should use it.
We will encourage this.
It's at page 253.
Now we are working on neutral citations from 1950 through to 2013.
From 14, Your Lordship has it.
Yes.
So we tried to make a list of that. Para 2. The decision of the Division Bench of the High Court of Gujarat giving its imprimatur to the decision of the Departmental Selection Committee in reducing the qualifying marks for the post of Supervisor Instructor Class 3 after publication of the result to facilitate the inclusion of candidates constituting horizontal reservation is under challenge in the civil appeals. That is reducing a criteria. Then if Your Lordship will go to Para 12. It's at 255, Para 12, right at the bottom, Your Lordships. The aforesaid advertisement does not give any room for any interpretation otherwise. It thus speaks about the manner by which a post has to be filled up, inclusive of a special reservation in the form of horizontal one. The power of either cancellation or amendment has to be exercised by way of an amendment to the advertisement, except in case of reduction of seats. Further, such a power has to be exercised either at the initial stage, which only means before writing the examination, or during the process, and thus giving ample indication that publishing the result would mean the completion and therefore the declaration of selected candidates would only be consequential. Para 13. The selection committee held a meeting on 5/10/2016 proposing to further relax the cutoff marks fixed only for the candidates belonging to the horizontal reserved categories. Accordingly, the cutoff marks for general category have been kept intact. Thereafter, a subsequent meeting was held on 17/12/2016, by which the earlier decision proposed to be implemented on 5/10/16 was cancelled. The meeting was attended by all the members of the selection committee. Thereafter, if your lordship go to para 23, where the discussion starts, that's at page 258 of the compilation. Another unique feature of the present case is that the selection committee had reduced the marks to facilitate horizontal reservation by treating it as a vertical reservation. Admittedly, the rules do not provide for such reservation to be treated as a vertical one. Likewise, the rules do not fix any cutoff marks. An advertisement made pursuant to a notification binds the parties. It has got all the trappings of a statutory prescription, unless it becomes contrary to either a rule or an act. A change, if any, can only be brought forth by way of an amendment and nothing else. Such an amendment, even if it is permissible, can be tested on the touchstone of Article 14 of the Constitution of India. It cannot be introduced to give an entry to a special reservation in a case where a right becomes accrued to a candidate under a policy decision reduced in the form of an advertisement to be considered for a post in the absence of any eligible candidate from the horizontal category. It is true that a candidate may not have a vested right to the post. However, it cannot be confused with the right to be considered in accordance with law. A law which enables a candidate to get a post cannot be changed to facilitate another group of persons, since the candidate acquires a vested right to be considered in accordance with law. And thereafter, they cite another judgment we have relied on, Devan Katti's case. And then they at para 25. Admittedly, in the case on hand, the appellants are entitled to get the post as per the advertisement issued. The advertisement has not been amended. It was modified on the advice of the government, though an earlier decision was taken on similar lines but wisely withdrawn. Fixing cutoff marks for a particular category has got a rationale behind it. Reducing it only for the purpose of providing employment to a particular category when others have already acquired some right would be an affront to Article 14 of the Constitution.
All right.
Yes.
And the Devan Katti's case relied on says that all...
The judgment in Manjushri and Tej Prakash was cited,
Yes,
and they, at para 29,
they differentiated.
and they say that it's not necessary for us to go into
Was to
that.
go into it.
On the facts, we do not think the said issue has any bearing.
They say it's different.
Para 930, they say the decision to reduce the cutoff marks is not based on objective criteria, namely the suitability of the candidate to the post, but for extraneous reason, that is to accommodate otherwise ineligible clientele. So actually the judgment can rest on this instead of going into any broader aspects of the judgment. Really.
Yes, Your Lordships. I'm obliged. So we've
Thanks,
given as many judgments
Thank you.
as we think is
Thank you.
necessary.